Hi Mrs. Olley, it's nice to see you today. How may I help you?
My fur coat has been stolen.
What happened?
I left my room key on the rack behind the reception as usual, but when I came back it was gone, and my fur coat has been stolen.
Please wait a moment, I need to check with our cleaner first. Sorry Mrs. Olley, our porter had apparently been cleaning the bust of the Duke of Marlborough and he did not notice the situation.
You should repay me for the cost of the coat, because this hotel were obviously negligent in failing to appropriately safeguard my key to the room.
We're really sorry for the coat, but actually our hotel is not liable for any of your loss.
This is not acceptable. How come?
Guests living in our hotel are bound by the terms displayed on the notice in the bedroom. It says, the proprietors will not hold themselves responsible for articles lost or stolen, unless handed to the manageress for safe custody. Therefore, in your situation, we exclude any liability.
Hi, I'm Colonel Crew. One was sitting in the lounge. I saw a person go in and come out again with a parcel about 15 minutes later. I guess this person was the thief.
It is your duty to take reasonable care to see my coat was not taken by any unauthorized person. There is a term about that within the contract and you have breached it.
The notice was clearly visible in the bedrooms and the exclusion clause unambiguously absolved the hotel of any liability for stolen items. Also, it was you who depositing her key on the board in reception and we have no responsibility to take care of that.
Well, that clause was not incorporated into the contract, so you must repay the money or I will sue your hotel.
It is not our fault, so we will see you on the court, Mrs. Olley.
My friend, Josie. What should I do and what will happen?
Olley, I believe you will win this case. The ratio decidendi for this case is that all terms and conditions must be brought to the notice of the other party before the contract is signed.
What does that mean?
Once it is signed, no party is entitled to bring any new terms into the contract. If any terms are offered, then there must be a new offer which the other party is entitled to accept or reject.
As the defendant, what we can provide to let the judge reject the appeal.
If there was a contract between the plaintiff and you, it must have been concluded before the plaintiff and her luggage arrived at the bedroom where she could have the opportunity of seeing the terms of the notice displayed there. Also, you need to prove that those words on the wall form part of the contract between the parties. And that those words are so clear that they must be understood by Mrs. Olley.
Okay, I get it.
Firstly, that the hotel had failed to take reasonable care as they were required to do contractually and under Innkeepers Liability Act 1863 S1.
Secondly, the disclaimer was not part of the contract and the hotel could not rely upon it. The contract for the storage of the coat was formed at the reception desk.